Yes, Mr. Hogman.
My lady, my lords, perhaps I can indicate at the outset how I propose to proceed. One thing I'm not going to do is to take you through our printed case in detail, not because we don't rely on it, but because we are absolutely confident that you will have read it. And in particular, as regards the three issues, we set out in the printed case a whole series of detailed arguments on all of which I think we continue to rely. And for reasons of time, apart from anything else, I'm not going to go through those in great detail. I've only got just under an hour and 3/4 in order to give Mr. Morici time to reply. So instead, I want to deal with matters in this way, if I may. Firstly, to try to place before the court some arguments at quite a general level. Much of this we had prepared in advance, but I've added to it over the luncheon adjournment in order to answer some of the points that Mr. Morici made. And so that, I think, will take me a little bit of time. And after that, I will deal with some of the cases, the four on which he particularly relied, 4 European cases and two of the English cases, and add 1 or 2 of my own. So it'll be general submissions followed by case law. That's the overall plan.
Will you at some point be addressing the point we touched on just before lunch about the individual and excessive burden? And
I most certainly will.
Whether as a good, wait, I mean, as a fallback position, I mean, I know that's not your main case.
Well, no, Lord, I'm not sure that we do regard that as a fallback position, but let me deal with
whatever,
it.
anyway.
Yeah, I certainly will be dealing with it, because one of our points is that you do need to draw a distinction between national measures on the one hand and a decision which impinges on a particular individual, where the concept of the burden is extremely important. Could I start then by setting out as clearly and succinctly and simply as I can the essential case on behalf of the respondent, Mr. Nigel Mott, for whom I appear, and some of this will be obvious, but I think it's important nonetheless to, as it were, to summarize it at the very beginning. So we say firstly that Mr. Mott's interest in the lease dated the 14th of May 1998 constituted a possession for the purpose of Article 1 of the first protocol. Secondly, the conditions imposed by the appellant on his fishing licence constituted a clear interference with that possession. Thirdly, as regards the nature of that interference, his primary case is that it constituted a de facto expropriation or deprivation of his possession. Fourthly, and alternatively, those conditions constituted a very severe restriction and control upon the use of his possession. And may I interpolate and flag up that I will be seeking to make some comments on the issue raised, among others, by my lady, Lady Black, where how hard and fast a distinction there is between the two concepts. I'll certainly be addressing that. But fifthly, and in any event, our case is that no fair balance has been struck between the demands of the general interest of the community, on the one hand, and the requirement of the protection of Mr. Mott's fundamental rights In other words, to come immediately to my Lord Conworth's point, he has been left to bear an excessive and unfair burden. Now, let me continue with some reasonably general propositions, but descending into slightly greater detail. Firstly, and we submit importantly, if not crucially, the possessory right in this case is itself in the nature of a right of use. Maybe my Lord Briggs, who first pointed this out in the context of the hearing, and I will take your lordships to the lease in a moment. We submit that there is a crucial distinction for present purposes between a possessory right which is in itself a right of use on the one hand, and a right which comprises the ownership of land or other property, to which, if you like, a use may be appurtenant, and that word is sometimes used in the cases. And it follows from that the interference here directly affected and encompassed the entirety and essence of the possessory right, save for the very limited ambit of the continuing license to fish, a small number of fish that are still allowed to be caught. Again, I interpolate that the court has been treated to some interesting suggestions as to the utility of the continuing right to catch a few dozen fish. We shall seek to show, and this is one of the points that I'll come to in answering Mr. Marici, we shall seek to show that those suggestions are unfounded. They bear no relationship at all to the real world, to the evidential case that the agency put forward. They are interesting advocates' points, but they don't actually take the case any further. But I want to stay with the main argument for the moment. Now, just in order to substantiate what I've been saying, could I take your lordships back to the lease, which is in Core Bundle Volume 2, tab F5, electronic bundle page number 347, I hope.
That rings a bell.
And it is apparent from the language of the grant itself that it is that which is demised is a right of use, the right to fish 2 stop nets and 650 putchers, together with the right to store equipment ancillary to the fishery.
As I understand it, the phrase "to fish 2 stop nets and 650 putchers" is simply a description of the amplitude of the fishing right.
Yes.
It's not a description of the demised property.
Well, my lord, that, however, is what this lease relates to.
Yeah.
It has, it calls itself a lease. It certainly has contractual effect, at the very least. Nobody's suggested that
I'm not suggesting it can't be a lease, on the contrary.
I do.
I'm just making sure I fully understand it as a matter of construction.
Yes, yes. My lord, it would be rash of me to, as it were, to debate issues of property law with your lordship, and I don't seek to do
Please
so.
do.
But I mean, you say it doesn't matter.
I say it doesn't matter. What matters
It's a possession.
for present purposes is to characterise the possessory right. There are some cases, and we'll look at one or two of them, in which the European Court has considered A1P1 in the context of a right of use. And this notion of, as it were, eliminating the essence of the right is not something that I'm dreaming up for the first time. It appears in the cases, but it's not.
Do any of the cases actually attach importance to the distinction
Yes.
between a real property right and a non-real property?
Maybe they don't articulate it in quite the way that I'm articulating it now, but they make it clear that the interference in question is with the use as the essence.
I was trying to make a point in your favour, that I was suggesting there might not, that in looking at the law through the prism of English property law may be a mistake. But,
Yeah, I respectfully agree. Particularly now I realise it's a point in
in your
my
favour.
favour.
Yes, I thought you might.
But no, I mean, whether one finds in the cases, as I say, the argument being developed in the way that I'm developing, I don't know, because it arises now because of the litigation between the two parties here. But what I'm saying is that I think one will be able to see how, in the case of a right of use, in the case of a possessory right which can be characterised as a right of use, then a different approach is adopted from what is seen in many of the cases cited by my learned friend, where it's said that if you've still got the land, then in almost all cases there is the possibility of using it in some other way. But that doesn't arise in this.
If you posit somebody half a mile upstream from Mr. Mott, who actually owns the foreshore and the relevant bit of the riverbed over which the fishing traps operate, yes, and fishes it as a right inherent to his ownership of the land, that person, call him Mr. X, has imposed upon him exactly the same restrictions, and let's suppose it's the same number of machines, and in all respects identical to Mr. Mott's case. Would it make, I think you're going to say, it makes a difference to the question which, if either of them ought to be compensated, that because Mr. Mott doesn't have the land but only the fishing right, he needs to be compensated, whereas somebody who has exactly the same restriction imposed upon him but owns the land and is fishing in right of his ownership of the land doesn't get compensation because he's still got the land. There seems to be something odd about that.
Yes, my answer to your lordship is that it might make a difference, not necessarily. I mean, one of the themes of the submissions that we make, as you've seen, is that we suggest that where you're talking about a decision relating to a particular locality which has an impact, we say a disproportionate impact, on a particular individual, that is a really rather different situation from what you see in so many of the cases, where the trailer and marina being one, where the challenge is to a national measure and where quite different considerations arise. I mean, it's a crucial point about trailer and marina, that the challenge was exclusively to the national measure or measures in question. And there's one sentence in trailer and marina towards the end, which we'll look at in due course, where Lord Newberger, or Lord Justice Newberger, as I think he then was, says, there may be a situation in which a challenge is brought against an individual decision, and that may give rise to different considerations. So trailer and marina allows for that possibility. This is the situation that we're in here. So I make the point that it's a right of use. I make the point that, yes, there is a right of way which can be which is obviously necessary to enable you to get to the land. Just looking at the photographs, and my learned friend and I have had the opportunity to visit the site. You have to go quite a long way across country in order to get to this particular part of the banks of the Severn. It's not a noted tourist destination, and and you need a right of way to get there. But it is to be noted that the right of way is granted to the lessors and not to the world at large. So tourism on a grand scale, such as Mr. Morici was engagingly painting as an alternative opportunity, falls at the first fence, as it were, because there's no legal right to do it.
Right of way appurtenant to his, whatever it is that he has under the lease.
Yes, the right of use, as I would invite your lordship to characterise it. Yes, exactly. And then another thing which is important is that it is a lease, obviously, for a term, as you've been told, of 20 years. The conditions were imposed, for relevant purposes, we're talking about the 3 years, 2012, 2013, 2014, although I think your lordship's decision will inevitably have implications for 15, 16, 17. But it all comes to an end anyway on the 31st of March 2018. I'm afraid we I don't know if my learned friends have got an answer to this. We don't at the moment have an answer as to whether it's a lease which is protected by Part 2 of the Landlord and Tenant Act. I slightly doubt it. But in any event, that is, we submit an academic question for present purposes because, and I'm sure Mr. Mott, sitting behind me, won't mind me saying this, he is not in the first flush of youth. He is a gentleman in his 70s. And we invite the court to say that for practical purposes, these conditions have deprived him of his livelihood for, roughly speaking, the last 5 or 6 years of his working life up until March 2018, and that is the central issue, the central burden with which this court, we respectfully submit, must grapple.
So you accept, or maybe assert, that any compensation claim would be limited to the period up to March 18?
I don't know if I'm instructed formally to make that concession. I'd have to take instructions about that, but I'm submitting that your lordships ought to proceed on the basis that we're dealing with matters up to March 2018. I don't think
But it might be. I mean, I'm not sure which way it would go, but one of your point is that this is a very one-off case where a particular person is affected in a totally disproportionate way by a scheme which is of general importance, where the effect of compensating him was actually very limited in terms of, it's not going on forever, it's just simply saying...
respectfully adopt those.
I think we can proceed on a fairly safe assumption that Part 2 of the Landlord and Tenant Act 1954 doesn't apply.
Yes, I would
it
say.
only applies to a tenancy where the property comprised in the tenancy is or includes premises which are occupied by the tenant and are so occupied for the purposes of the business.
Oh, it's occupied. Well, anyway, I wouldn't necessarily go there. I don't think we need to worry.
Can I just check that
Yes,
he
ma'am.
won't have to buy in salmon to pay the salmon rent on this?
I'm so sorry, I didn't hear.
That he won't have to buy in salmon to pay the salmon rent on this lease?
With respect, that's a very good question. I need to take instructions.
I suspect he won't, but...
Yeah. What he, just to anticipate the point straight away while it's in my mind, what he undoubtedly was doing and would have had to do, but for the restriction, is to maintain this, the whole structure, the equipment. I think my Lord Kerr pointed out that there are bound to be substantial maintenance costs. He constructed the whole thing himself. The whole structure he put in place with his bare hands.
Including the post in the river?
including the posts, as I understand it, yes. Not an easy task for a man to do, and undoubtedly these things do need maintaining, and because he has had no commercial income from the site since 2012, inevitably it has deteriorated. The photographs that you've got, which I think were taken in 2013, do not remotely represent the position today, because it's no longer and cannot be used. And so, my lords, my lady, my lords, the right of use, as we submit, being eliminated, it's hard to imagine a case in which there was not a more clear de facto expropriation or deprivation. But I'll develop that a little more in a few moments. So, my lords, lady, going on with some general propositions, let me make in a slightly more cogent or slightly more direct way the point that I touched on earlier. The challenge in this case, brought by way of judicial review, was not directed against any national measure, whether legislative or otherwise. The challenge was instead strictly limited to decisions by the appellant with regard to the imposition of licence conditions affecting the respondent's possessory right and that challenge is maintained in this court, obviously, on the basis of Article 1 of the first protocol. So it follows, and this phrase maybe a little bit surprising in a human rights case to find this phrase appearing for the first time only sometime after lunch. No question arises here of applying to the decisions in issue in this case the so-called margin of appreciation, which I don't think anybody's mentioned yet, which is a concept we submit which arises only when evaluating the compatibility of the convention with a national measure. In fact, my learned friend hasn't sought to rely on that particular concept, and the reason why it didn't fall from his lips once this morning, as far as I know, is precisely because, as I said, we are not challenging a national measure, whether legislative or otherwise. We are complaining about the way in which the Environment Agency have exercised their decision-making powers in such a way as to impose an excessive and unfair burden upon the respondent. Now, let me go on one step further. We submit, on the other hand, so it's not a case of challenging a national measure and discussing the margin of appreciation, but on the other hand, we're equally not engaged here now in challenging the rationality per se of the decision-making by the appellant. So outside the scope of a human rights challenge, outside the scope of A1P1, which is engaged here, we might be required to look at the question of rationality. Indeed, rationality certainly did arise on the substantive issues longer before this court. But it isn't actually a question of rationality, and therefore your lordships, your ladyship and your lordships, we submit, ought not, as it were, to say, and again, I don't think this invitation has been offered, that there's a sort of range of possible approaches which the Environment Agency might adopt. Instead, the test here, and again, I believe this to be common ground, is one of proportionality. It's not rationality, it's a clear case of proportionality. Or otherwise. And it's for that reason that, as you've seen, that in our printed case, we cited what is perhaps a helpful and maybe even classic articulation of the proportionality test in Bank Mellat. And could I please take you to that? It's in Authorities, Volume 1, Tab 2, EB page number 621.
621?
Yes. And I think we can go straight to the judgment of Lord Sumption at EB 658, paragraph 20. Where Lord Sumption says, and this is just under the reference to the Aguilar-Quiller case, that the question depends on an exacting analysis of the factual case advanced in defence of the measure in order to determine, one, whether its objective is sufficiently important to justify the limitation of a fundamental right, whether it is rationally connected to the objective, three, whether, and this may be important for present purposes as I shall seek to show, whether a less intrusive measure could have been used, and four, whether having regard to these matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. These four requirements are logically separate, but in practice they inevitably overlap because the same facts are likely to be relevant to more than one of them. Said something very similar and acknowledged that there was no difference in substance between what he was saying and what Lord Sumption was saying. Now, can I take matters a stage further and make this submission, which echoes something which I think my Lord Culmouth mentioned this morning? Our respectful submission is that the exacting analysis of the appellant's factual case, which the courts are required to undertake, lies in the first place with the court of first instance, which will review in depth the factual and evidential material.
Well, I mean, there's a slight problem that I don't think the first court looked at this in terms of proportionality, did it? I'm interested in the way you put it, but I was just trying to see whether in dealing with A1P1 they actually...
Well, my Lord, I think in substance, yes. I should just say before I go any further that we have noticed, prompted by something said by my learned friend, which I'll come on to, we have noticed one small error in the judge's judgment. So I should make that clear straight away, and I'll come back to that. But we do submit that the approach of the court of the judge, the approach of Judge David Clark, is one that should be respected. If I could just go on for a moment to complete what I'm saying. Occasionally, we suggest the analysis by the court of first instance, will need to be expanded or amended by the Court of Appeal. That certainly happens. But we submit with very great respect, obviously, that it will be rare for this court, as the Supreme Court of the United Kingdom, to interfere with the exacting analysis of the courts below, save perhaps where some distinct and novel point of law arises, which doesn't seem to be suggested here. So, in other words, I suppose I'm seeking, first time since 2 o'clock, respectfully to adopt what the point that was placed in argument this morning by my lord in saying that, yes, that it certainly would be rare for your lordships to overturn a piece of analysis already undertaken and confirmed by the judge and the Court of Appeal. And I'll say a bit more about that and take you to the judgment in just a moment. But let me advance, if I may, one further rather general proposition about the question of environmental factors. We don't, although my learned friend has obviously placed importance on the environment and the environmental factors underlying the work that the agency have done, and nobody can possibly dispute the importance of that work, we don't understand the appellants to be submitting that the fact that the interference here was on environmental grounds has the uniquely significant implication of displacing the need for that exacting analysis and precluding, in principle and in all circumstances, a requirement for compensation as a means to achieve a fair balance.
Well, I think he doesn't put it as high as that, but he does say that the environmental context, in particular, the polluter pays principle, as enunciated in our recent judgment, is relevant in the sense that the government shouldn't be paying people for damaging the environment. So I think it would be helpful to have your submissions on that.
Yes. Well, let me go on and say a few things about that. I do make the point as a starting point that it does not seem to us that the case here has been put on the basis that because it's an environmental case, an unfair and excessive burden can never occur. If that's the way it were to be put, we would submit that would plainly be wrong. The reason we say that is along these lines. We're in the United Kingdom. We're not in Greece of yesteryear, when the Navy might appropriate a piece of land in an unlawful way without compensation. We're in a situation in which these issues will inevitably arise, and do arise from time to time, if the state, speaking generally, seeks to enact a measure for a particular social purpose. The environment is not the only important social purpose, crucial though it is, particularly at the present time. There may be many other social purposes for which the state seeks to interfere with possessory rights, and it would be wrong we submit for this court, as it were, to elevate environmental policy among other social policies as in terms of their significance with reference to the convention. The whole point of the convention is precisely as we've submitted, to strike a balance between the interests of the majority as reflected through the state and through the national government and the fundamental rights of the individual. That is absolutely at the heart of the instrument itself and of its constitutional significance. And that must apply. In fact, one could even say that it's all the more important when you are dealing with an issue of social policy which is extremely important for the community, to preserve the protection for the individual. That is an essential part of the way that our democracy is constituted. A safeguard, if you like, against elective dictatorship. So the proposition that the fact that this case turns upon a particular aspect of social policy and therefore the applicability of A1P1 can in some way be cut down or restricted is one that should be rejected on grounds of broad principle. Of course, the reason why the state seeks to introduce the measure is relevant, and certainly it would be relevant if the reasons were comparatively unimportant or even capricious. But since we do live in a democracy, that's probably, one would hope, unlikely. But my central point is that one has to look alongside the grounds and the reasons of social policy for the introduction of the measure. One has to look at its impact upon the individual, and one has to look at the burden placed on that individual. This might be quite a good moment, in fact, to look at trailer and marina again, which I think is in Authorities Bundle 2, please. Tab 15. Our learned friend has helpfully taken you to much of this, so I won't
1248.
I'm sorry, my lord.
E1248, I think.
Thank you very much, yes. Let me just touch briefly on paragraph 58 in the judgment at EB page 1261, on which understandably some emphasis was placed, and where the Court of Appeal say that the right analysis seems to be that provided the state could properly take the view that the benefit to the community outweighs the detriment to the individual, a fair balance will be struck without any requirement to compensate the individual. Now, it seems to us, and we respectfully submit, that sentence only makes sense if you are talking about a challenge, as Trailer and Marina ex hypothesi was, to a national measure.
Because otherwise you're talking about incommensurate objects, aren't you?
Yeah.
The good of the community as a whole and the good of individuals.
Yes, yes. Well, I suppose that comparison also arises, I suppose, in any human rights case, my lady, I'd have thought. But my point is that sentence shows, but it's confirmed throughout the judgment, which I don't intend to go through line by line, that the challenge here was to some national measures. And one can see that, and this is the part of the judgment that I want to highlight. Mr. Murici didn't really get to the nub of this previously. I make no complaint. Is that one can see, particularly on page 1263, an analysis of what the what the complaints were. And one can see, for instance, at 67, that the complaint was effectively based upon the impact of a national measure. And at paragraph 70, which is what I want to come to, one can see the court saying that when you're challenging a national measure, you have to be able to show that there are no other national measures which, if properly exercised, this is the second line of paragraph 70, no other national measures which would prevent the use of the statute from invading convention rights. Fair enough. But the point I want to make is that at the end of paragraph 70, Justice Neuberger goes on to say that if none of these provisions assisted, in other words, the measure still survived scrutiny because they resulted in adverse decisions for the landowner, it would be necessary for him to attack the decision as unlawful by reason of their violation of a convention right, rather than to attack the statute which provided for them as incompatible with that right. That's where he's drawing the distinction, which I'm seeking to draw and on which I seek to rely. And I'm saying that we clearly here fall into the latter category or the category of attacking a particular decision as unlawful, rather than attacking the statute or the policy matrix as being incompatible with the right. Now, perhaps this would be, I want to come on in a moment to take your lordships to the judgments of the judge and the Court of Appeal, but this might be, there is one more thing I want to say under that general heading, because I haven't really addressed the issue of polluter pays, which your lordship kindly flagged up. We would seek to draw a distinction between protecting the environment as a form of social policy on the one hand, and being a polluter in the sense of being someone who is in breach of some regulatory requirement. Now, I'm not sure that was a distinction that arose for your lordship's consideration.
No, I mean, I think I was interested because the statement in paragraph 2 of the Fisherman judgment, which just summarise some of the international statements about it,
yes,
was obviously dealing with a particular case, which was of water pollution. But I was interested by Mr. Moric's reference to that recent summary in the Global Pact, which talks about cost of pollution and other environmental disruptions and degradation. And he was suggesting that your client, like it or not, was doing something which was causing environmental disruption, because it may not have been some years ago, but because of the depletion in stocks.
Yes.
And what he's doing now is inevitably an environmental disruption in that sense.
Yes.
Would you accept that?
Well, I wouldn't put in with respect put in that way. I mean, may I offer these comments in the hope that they're helpful. Firstly, looking at the extract from the draft Global Pact presented by President Macron, which your lordship quotes in paragraph 2, that is clearly concerning itself with obligations which lie upon states. It's being presented to the United Nations, and the parties in question are
No,
sure.
it's directed to states to
Yes.
ensure that their laws conform to that and
Yes.
ensure that
Yes.
the polluter pays. I mean, that's the whole point of it.
Exactly. So, my lord, this doesn't require, I would say with great respect, any adjustment or amendment to the analysis which I've given. In other words, that this is emphasising the importance of the state incorporating this policy, among others, in its national policy and where appropriate, legislating to give that effect. But that doesn't mean that until Mr. Mott was subjected to the licence conditions, he was doing anything wrong.
No, it's not that he was doing anything wrong. He was doing something which, as has been found now recently, was damaging the environment.
Well, but only after an assessment was carried out. It wasn't self-evident that to him or to anyone else that salmon stocks were depleting. Indeed, his personal view, held in good faith, was that this was not a case of mixed stock. In other words, of salmon being prevented from re-entering the Y in order to spawn. He had a completely different personal interpretation.
So this is not a matter of assessing the respective moral blameworthiness of the parties. This is a question of objective fact.
Yes.
Whether the maintenance of his method of fishing will have an adverse impact on fishing stocks and therefore the environment.
Yes.
So it doesn't, I think, serve to tell us, as I'm sure is the case, that Mr. Mott was not in any malign sense involved in inflicting damage on the environment. The question is whether the agency, in the discharge of its public function, has to devise rules which may impact on people such as your client, but which are for the greater good in the protection of the environment.
Yes, my lord, I of course I respectfully agree, but I can only, as it were, gently repeat the point I made earlier, which is that it cannot possibly be the case that President Macron intended that there should be no scope for the operation of Article 1 of the first.
I mean, I don't think we should. President Macron didn't have much to do with the draft.
That was my.
I should declare an interest in the sense that I did. I was involved in it. But so I think we should avoid getting too close involved in discussing.
Thank you.
Defects in the drafting.
I didn't.
So I think let's move. It's a more general point, which I think is significant. I think Mr. Morici is saying there's something about environmental degradation or damage, which has special status under European law generally, if not specifically under the ECHR.
Yes, and I'm not disputing that as a general proposition, but I'm saying that it is one important social policy among many, and that this court is required by, I suppose, by the Human Rights Act itself, nonetheless to apply A1P1 to the situation, bearing in mind that there is no challenge whatever here to the national measure, but only the disproportionate impact of the decision the agency took. And let me add in one further very important point, which we haven't really touched on yet, which certainly didn't feature very strongly in Mr. Morici's submissions, which is that the problem for the agency in this case is that although they undertook an assessment of one side of the equation, namely the environmental side, conceding everything about its importance, they actually undertook no assessment whatsoever of the proprietary interests of Mr. Mott. Not only was there no acknowledgement on the ground, as it were, in the river, of the fact, for instance, of the crucial point that that he had a right of use, which itself must be relatively unusual, as opposed to a simple right of real property. That concept was not even acknowledged in the 2.5 hours that my learned friend addressed you this morning.
But I mean, was it? I can see the force of the case that whatever the general picture is, they were under a duty, public law duty,
Yes.
to take account of the very special circumstances of Mr. Mott's case,
Yes.
and failed to do that. And since they had a power to compensate,
Yes.
they should at least have considered that possibility. Was that the way the case was put at any stage?
Yes, absolutely.
Well, you say absolutely. I'd be
well, I
interested
mean,
to see where it was, but anyway,
Well, my learned junior is here.
anyway, carry on. I mean, I'm sure he'll point us to it.
Yes, well, I mean, he will, I think, be able to draw.
I mean, that's a sort of Wednesbury failure to consider point, rather than a...
Well, I mean, I think it probably was put in part as a Wednesbury point, but I'm trying to.
It's not just a Wednesbury point,
No,
is
no,
it?
sorry, that's-
Because clearly, when a public authority is deciding whether or not to do something which has an impact on the fundamental rights of an individual,
Yes,
it's got to consider them in relation to that individual.
exactly, and that's
And
precisely
the fact that it hasn't is some straw in the fair balance
Yeah.
issue, which is the same as the proportionality issue. It comes to the same thing.
Yes, my lady, that is exactly our position. I think I've said that not as succinctly already, but I repeat it again, and I rely on that, if I may, respectfully, in answer to my Lord Carnwath, which is that it's just not a sufficient answer in an A1P1 case to refer to environmental policy, however important. And if I may just repeat the point that I was halfway through making, which is that perhaps it would be a different matter if there were some regulatory breach, if he were a polluter in that slightly fuller sense. But it's conceded that he's not. I mean, Mr. Morici said more than once he's not a polluter in that rather more literal sense of the word. There is a danger in using the word polluter too broadly. Although Mr. Morici makes the rather subtle and skillful point that government policy on this dates back to the 1990s, before Mr. Mott entered into his lease, there's absolutely no evidence of him having been, as it were, consulted about it, or having any knowledge of the incipient government policy that existed in the 1990s. The other point, perhaps, which I could deal with before descending into slightly factual issues, is the point that I promised to come back to, which is the distinction between deprivation and control. Now, I mean, the parties obviously agreed in this case to subdivide the issues in a particular way to make the discussion manageable, and I hope that's not unhelpful. And of course, based on that analysis, my position is easy to state, and I stated it at the beginning. Given that we've got, if you like, the two issues, the third issue too, which is the answer to which we suggested, taking into account the two issues, de facto deprivation or control, it's easy for me to say, well, because this is the way that advocates are allowed to put their cases forward, my primary case is de facto deprivation, alternatively control. And that enables me, as a matter of presentation, really to say to your lordships, I don't mind, as long as I win, I don't mind on what basis I win, and I'm happy, I submit that I can win on either basis. I suppose, looking at it objectively, one would have to accept that, as indeed the courts below accepted, that one may shade into the other. There almost certainly isn't a hard and fast distinction between the two. But certainly, if that is right, then it enables us to say that if the extent of interference, using that phrase in the broadest sense, if the extent of interference is at the more extreme end of control, then it's much more likely that compensation will be required to avoid a violation than if the interference is at the less severe end of control. I was going to suggest, by way of generalization, that some of the factors that the court will look at when evaluating interference might include the following: the manner and duration of the interference, manner including such things as, whether it affects the essence or not, fault on the part of the owner, which in one or two of the cases has been demonstrated. And another relevant factor, which is certainly relevant here, and again features in some of the cases, the extent to which there have been procedural safeguards. So, in other words, if it could be shown, and in one of the cases it was shown, that the individual concerned knew perfectly well what they were doing, took a risk, if you like, then that may affect the balance. But other than that, then simply to impose the control, and I think this is what happened in the case of Mr. Mott, at very short notice and without any advanced discussion whatsoever. And by definition, that must be the case because they never even thought about his A1, P1 rights. Indeed, they were advised, it says so in the papers, I'll give you the reference, that no compensation would be payable. The Environment Agency were given that express advice. Wrongly, we submit. They've just advised that there was no possibility of compensation being payable. And that's why that may be one of the reasons why they didn't engage in any form of procedural discussion with the respondent. So those may be some of the factors. And perhaps what we say on this, which is that there may be, if you like, a sliding scale. One of the things which suggests that is not an entirely invalid approach is that I think the analysis of the courts, both here and in Europe, has always been that under Article 1 of the first protocol, the first sentence, which talks about not being about being entitled to enjoy your possessions, is treated as a general statement, and then deprivation and control are treated as specific examples of the general statement. I think it emerges from Sporrong, and it's certainly endorsed by Lord Reed in the AXA case, which I think both sides have referred to in their brief. Now, let me move into something more specific and take you to the judge's judgment. And I'm doing this in part, at least, in order to seek to persuade you and demonstrate to you that this is a case of de facto deprivation. So we need to go to at tab
Starts at page 147.
Yes, thank you very much, my lord. Thank you. So In the judgment, the A1P1 issue is, it starts at paragraph 80 on page 167. And the crucial passages come on pages 172 and 173. So at paragraph 93, the judge observes and holds that it was important that Trailer and Marine was a challenge to the legislation as a whole and not to a particular executive decision made under it. Thus, the question, he says, of infringement of A1P1 had to be considered in principle, and issues as to the margin of appreciation related to the general judgment, this is in the Trailer case obviously, the general judgment of the legislature and not the specific circumstances of the claimant. Although the court was referred to the possibility that the measure could amount to a de facto deprivation of property, it was not contended that the legislation in fact had that effect either on the claimant or generally. The court recognised at paras 70 and 71 that there were powers available to compensate an owner, referred to as an extreme case, where the application of the legislation resulted in a de facto appropriation or was necessary, this is an alternative, to avoid a breach of A1P1. It does not therefore support a conclusion, which is the conclusion that Mr. Ricci sought to draw, that any restriction on property on environmental grounds can be made without a requirement for compensation. Turning then to the decisions challenged in this case, it's accepted that the aim pursued was a legitimate one. The real issue is whether the steps taken were reasonably proportionate. So, Lord, he does deal with it in that way.
Fair enough, yeah.
To achieving that aim. Given the finding that there was no reasonable basis for concluding that, so this is the finding that no longer survives, so I won't read this out, but he says it follows that those restrictions cannot have been proportionate. That was his conclusion. That doesn't survive. Then he goes on at paragraph 95, and it's important, of course, that he did deal separately in detail from paragraph 95 to 99 with, if you like, the factual basis which underlies the argument in this court following the decision of the Court of Appeal. If he hadn't done it, then we might be in a different situation. And he goes on to say this, 95, and I won't read all this out, but just pick out the important bits. If I had concluded that the agency had a reasonable basis to consider that 56% or any substantial proportion of the fish caught would be prevented from spawning in the Wye, which is where we are now, the question whether the restrictions imposed amount to a deprivation or a control is not an easy one. The claimant's right, and he recognises this, is a purely economic one to catch fish using a particular method. If he's prevented from catching fish, and again he recognises the point, his right is to that extent extinguished, not merely made less valuable. It is not a right appurtenant to some physical asset, such as a piece of land, which continues to exist and can still be used or sold, even if less valuable. On the other hand, he accepts it's not a right to catch a particular number of fish, and was already subject to some control, in that the licence required payment of a fee and could limit the season in which he was permitted to fish. Even though the catch limit had the effect of restricting his catch to some 5% of the previous level, he still in principle owned the right and could exploit it to that extent. Now, we have a slight concern over those last few words in paragraph 95, and he goes on in paragraph 96 to say what he means. In my judgment, this case, like that in Back, has elements both of deprivation and of control. The claimant's right, he says, is largely but not entirely extinguished. It could be exploited and would presumably have some small value if sold for leisure interest rather than commercial use. Now, my lords, let me just pause there for a moment, because the submission that we have made throughout and continue to make, adopting the phrase no meaningful use, is that this is unambiguously a case in which the conditions imposed mean that the possessory right has no meaningful use. I hope I can say without fear of contradiction that it has no meaningful commercial use, at least in the sense of allowing the fishing business to continue. On the contrary, it hasn't even been possible to pay the costs of maintaining the structures because there's no income coming in.
Yes, when it said in paragraph 95 that there was not a right to catch any particular number of fish, well, that is right, but it was a right to have that number of butchers
Exactly.
out. And it would appear that, on the whole, they caught a substantial number of fish.
Correct.
in those structures. So he'd got a right to catch as many fish as those structures would trap, I suppose.
Now, in paragraph 96, he goes on to explain what he meant in paragraph 95 when he said, by saying this in the third sentence, the second sentence: the claimant's right is largely but not entirely extinguished. It could be exploited and would presumably have some small value if sold for leisure interest rather than commercial use. Now, in saying that, he is overlooking the restriction on disposition in the lease, and I don't think I'm sorry, I should have highlighted this when we were looking at the lease, but let me just simply read it out. It is, in fact, without troubling you to go back to it, clause 2D imposes an obligation on him not to assign, let or part with possession during the term, save upon very special circumstances the death or disability of either or both of the tenants. In that case, the interest can be assigned within the family, subject to the written consent of the landlord. So basically the answer is he can't sell it, and the lease prohibits him from doing it.
Well, sorry, what's the point? Are you saying
Well,
you can't use it for leisure purposes?
I'm coming to that. I'm coming to that. What I've said so far is that the judge, unfortunately, was mistaken in thinking that the 5% point would have enabled the lease to be sold. That could not happen.
Oh, I see.
Now, as for leisure and tourism purposes, if I can go on and deal with that. Firstly, I've already pointed out that the lease effectively prohibits that too, because the right-of-way across country, I'm not quite sure how far it is to the nearest proper road, 2 or 3 miles, I think, at least. Quite a bumpy journey. The lease does not allow a right-of-way to any third parties in any event. So that effectively it eliminates that point in itself. Secondly, this form of fishing by butchers is not notable for its popularity in the leisure industry. I mean, it's essentially a commercial thing and not a leisure thing anyway.
I don't think that was the case being made against you. I think it was that it was a historically interesting way of fishing.
Yes.
And people might want to come and have a look at it.
Yes. Well, let me deal with that because with respect to my learned friends, we consider that is misconceived. They relied for this on the technical case in Appeal Documents Volume 2 at tab F9, and it starts at page number 410. There is a passage, a helpful passage. My learned friend referred to page 453, but before I get to 453, could I please invite you to go to 415? Where we see that this is all about, essentially all about net limitation orders, not about historic installations at all. What is said on page 415, starting at the beginning, I won't read it all out, is that the net limitation orders would run for a period of 5 years to allow a further study to assess the heritage value of salmon fisheries to report. And by the way, I understand that there is a clear distinction between leisure and tourism use on the one hand, which is prohibited by the lease, and heritage value, which is a more it's more conceptual. It doesn't actually relate to anybody visiting the site. It's something that...
No, it's just a good idea. It makes us feel good that there are still people there with their butchers on the Severn catching the odd salmon. That's what it means.
Thank you, my lady. As always, I adopt your ladyship's formulation with one reservation, which is the point that I'm rather badly trying to make, which is that this relates, the heritage issue relates to net limitation orders. It relates to nets, various kinds of nets, and not to butchers. And you see that negatively on page 415, because 415 shows that this is all about nets, and especially not only the first paragraph on 415, but the last paragraph, which is entirely about lave net fishing. And just without going through the whole of it, the last paragraph, this fishing method, meaning lave net fishing, is unusual and should be preserved. By retaining a small heritage fishery, it allows us to take account of the cultural value of the lave net fishery to the region. Your lordship, your ladyship put that point more bluntly a moment ago, but that's what it's all about. And it's lave nets and not butchers.
But the later reference does include butchers, doesn't it? The one that Mr. Maurice...
Yes, but if we go to 453, again, there's a misconception here, an unintentional misrepresentation here, because what 453 says, the passage you were taken to, a small regulated fishery, obviously referring to the net limitation orders, will help maintain the heritage value of the methods used if the future assessment concludes heritage value on all or part of the fishery. Although the historic installation fishery was not part of this NLO consultation, the catch condition imposed on them in the last 3 years means that the ranks that choose to operate will primarily be doing so as a heritage initiative. So the position is entirely, if you like, speculative at this stage in terms of the agency's assessment. And the point that we would make, applied to the facts of this case, is that there is no evidence and no indication in the judgment that the heritage point, as distinct from leisure and tourism, was one which ever featured in the agency's case. My learned friend will be able to say whether it featured in the Court of Appeal, for instance, but I believe I'd be right in saying that a heritage argument may well have appeared for the first time in this court. And it's not one, it's something that may have been for the future. It's not something which realistically applies to a gentleman in his 70s whose lease is about to come to an end and who would have been looking forward in the last few years of his working life to continuing to earn a reasonable income from this commercial site. And the notion that heritage or tourism or leisure can be categorized as a meaningful use from his point of view, we respectfully submit, without intending any impoliteness, is simply fanciful. The judge then goes on in comments which we certainly do adopt and submit are correct and not mistaken. He goes on to say well, let me first address the final sentence in 96. He says, given the extent of the restriction imposed, which eliminated at least 95% of the right, this is the final sentence of paragraph 96 of the judgment, it is to be considered as closer to deprivation than mere control, and that balance is relevant when considering proportionality.
So that is the answer to my point. I mean, he's specifically considering proportionality in the sort of grey area between deprivation and control.
He is. But I want to go on and make this point, if I may, that given the fuller analysis that I have offered as to whether that 5% constitutes a meaningful use, and we submit it doesn't, for all the reasons I've just outlined, which I won't repeat, had the judge had the fuller analysis that I've just advanced, he would, we submit, have categorized this as a case of de facto deprivation. So, which of course is a fortiori, the conclusions that he reached. Then he goes on to make these rather more general points, which are applicable really, whether it's de facto deprivation, control of use, or something in between. He says, in adopting the measure decided on, there is no evidence that the agency considered the extent of the effect on the claimant and his livelihood in any meaningful way at all. Though the HRAs refer to the desirability of permitting the continuation of historic methods, they did not address what the consequences would be for the rights holders affected at all, looking no further than their own statement of the conservation objective. There is thus no evidence that any balanced consideration took place at all. It would have been relevant to that consideration that the claimant's rights were of a commercial nature, so that by making them uneconomic to exercise, he was being deprived of his livelihood and not merely of a pleasurable leisure activity or the opportunity to maintain an ancient tradition. So far as the claimant is concerned, the position is exacerbated. So this wasn't, if you like, the central point. This was an additional point which exacerbated the central point, because the method chosen of levelling all permitted catches down to the previous lowest meant that by far the greatest impact fell on him. So that point is an exacerbatory point, an ancillary point. The central point is that the use is extinguished, but that is made worse when the method chosen is to level down. Whereas others, he says, who may only have used their rights for leisure or hobby purposes would be less affected and possibly scarcely affected at all. In my judgment, the effect is that even if the agency could properly have imposed the total catch limit that it did, meaning covering everything, nets, rods and putchers, the size of that limit and the way it was apportioned would still have meant that the claimant was required to shoulder an excessive and disproportionate burden, such that a breach of A1P1 could only be prevented by a payment of compensation. And I just quickly add that, as I understand it, it may be relevant to point out that, yes, an assessment was carried out. My learned friend showed you some of the documentation. An assessment was carried out on the basis here of levelling all permitted catches down to the lowest level. So I'm sure I'll be corrected if I'm wrong about this, but my understanding is that no assessment was conducted, which Lord Sumption's language suggests was mandatory. No assessment was conducted at any higher level, either in aggregate or as relating to Mr. Mott. No assessment was conducted to see to what extent the levels could be increased such that the injury to environmental interests would, though marginally greater, would nonetheless be acceptable. That's by definition, since the agency never applied their minds to the point, nothing prompted them to go down that route. There's no finding by the judge that any particular level was acceptable. He says very plainly, even if the agency could properly have imposed the total catch limit that it did, it created an excessive and disproportionate burden. He couldn't say more than that. He couldn't deal with other possibilities because the agency had not considered other possibilities. Other possibilities would include lifting the aggregate catch limit, lifting the limit on historic installations, making Mr. Mott an exception. Would that, in their assessment, have caused any significant impact on the interests which, by national policy, they had to protect? That essential balance was never struck. And Mr. Mott was never invited to contribute to the discussion. And then if you look at the judgment of the Court of Appeal, which is, as you know, at starts at page 119, and the relevant passage is at page 141. And the court in effect adopts the conclusions of the learned judge. For reasons of time, I won't go through the passage, but it's essentially from.
Well, it's quite a short passage, and I'm sure we've all read it. Thank
you very much. Paragraphs 87 to 89, and your ladyship. So that's the submission that I make on that. And I think if I'm going to...
You make the point that he was never invited to comment.
Yes.
Where do we find the first letter where he was informed what they were proposing to do, and his response to that, perhaps?
Can I
yes,
provide that answer?
Thank you.
If at all possible, but by 4 o'clock. So may I spend 15 minutes or so just dealing with some of the cases, because unless your ladyship, unless your lordship.
Which is the best case from your point of view?
Right. Well, faced with that invitation, there are two cases, to which I was going to draw attention, which haven't been mentioned. I don't know whether these are to be regarded as the best cases from my point of view. I'm not entirely sure, but there's a case. I can't for the moment find my note on it. Sorry.
I don't know if it put you off your order.
No, not at all.
It's always useful to know the highest point you can put it.
So let me refer you first to a case called Broniowski, which is at tab 21 in the Authorities Bundle, volume 3. Um,
1387.
Yes, thank you. So this was a case, and I think the relevant part of the head note is at 1390, little p. Yes. So it was a case in which domestic legislation had been enacted controlling the grant of compensation to certain citizens following the loss of their land consequent upon boundary changes. So effectively what happened was the level of compensation was reduced from 100% to 2%, and the key point appears in little p of the head note at page 1390, and this is what I had in mind in a comment I made earlier. The court holds this: by imposing successive limitations on the exercise of the applicant's right to credit, and by applying practices that made it unenforceable in practice, the state had rendered the right illusory and destroyed its very essence. Moreover, the uncertainty in which the applicant found himself as a result of the authorities' conduct was itself incompatible with Article 1 of Protocol 1. His situation was compounded by the fact that what had become a practically unenforceable entitlement was extinguished by the December 2003 legislation. Furthermore, that legislation operated a difference of treatment between claimants. Although the state was entitled to expropriate property and to reduce the levels of compensation under legislative schemes, Article 1 of Protocol 1 required that the compensation for property taken by the state be reasonably related to its value. The applicant's family had received just 2% of the compensation due under the legislation applicable before the entry into force of the protocol for Poland, and there was no reason why such an insignificant amount should per se deprive him of the possibility of obtaining at least a proportion of his entitlement on an equal basis with other claimants. The applicant had had to bear a disproportionate and excessive burden which could not be justified in terms of the legitimate general community interest. And then the other case which I had in mind to mention is a case called Vasilescu, which is in volume 4. At tab 44. Page 2109. Which concerned the seizure by police of 327 gold coins. And the complaint was that the applicant had been prevented from regaining possession of his property. I think in this case, the court held that it was a case neither of deprivation nor control of use, but it was nonetheless a violation of A1P1 as a de facto confiscation. And perhaps a useful paragraph in the judgment to refer to is on page 2129, paragraph 53. The court considers that the loss of all ability to dispose of the property in issue, taken together with the failure of the attempts made so far to have the situation remedied by the national authorities and courts, has entailed sufficiently serious consequences for it to be held that the applicant has been the victim of a de facto confiscation incompatible with her right to peaceful enjoyment of her possessions. In conclusion, there has been a violation of Article 1 of Protocol 1. Those are two new cases. Can I make brief reference to the 4 cases that were highlighted by Mr. Morici, which were Boehner, Traktora, Fredin, and Posti. I need to. I can probably do this from my notes and make some points on them, which your ladyship and your lordships would be able to consider when in due course, unless you'd rather we went all the way back.
Well, just give us your points.
I thought that might be helpful.
Well, you haven't got long, so
No.
we'd rather hear your points.
Absolutely. I mean, I'm near the end anyway, so I'm not running out of time, but I think it would be less onerous if I just give you the points and you can consider them. So Boehner was the one in which, by legislation, the public were allowed to fish with hand-held tackle in certain waters where previously the applicant had enjoyed an exclusive right. The applicant owned the land, and hence his right to fish was appurtenant to the property, unlike the present case. He had not been deriving income from the fishing, as far as we can see, and could claim no direct loss of income, nor a specific and concrete reduction in property value. And moreover, the challenge was to the legislation itself. So for all those reasons, we submit that Boehner can be distinguished or not. No great weight should be attached to it. Traktora was the one about the withdrawal of a restaurant license, which constituted a control of use because I think it was the case that the property right was retained. So that's one distinction. The second distinction is that this again was a challenge to a measure, and the decision about fair balance was in the context of the margin of appreciation, which doesn't apply here. Fredin was the gravel pit license, control of use case. The point that we wanted perhaps to highlight on Fredin was that it was held that it was found as a fact that at the time of making their investment in the gravel pit, the applicants were very well aware of the potential for the revocation of the permit, and that is referred to in paragraph 54 of the judgment. And so far as Posty is concerned, yes, there was a limitation of fishing rights, which in that case the court held to be proportionate. But it's clear from the judgment, I think Mr. Morici very fairly pointed these matters out, the interference did not completely extinguish the right to fish for salmon and trout in the relevant waters, and they had received some compensation. Is there anything else? My learned friend kindly drew something to my attention in answer to a question that was raised. Dig out the reference. Thank you. Okay, just leave that open. So I think Lord Culmouth asked about the sequence of events leading up to the notification
Yes,
of the
just
licence.
and reference the correspondence, but don't take us to it.
It's contained really in the statement of facts and issues
Yes, I saw it there.
Yeah.
I wonder whether there are any references, but it doesn't matter. I mean,
I think this is this it contains the gist. In other words, at page 31, pages 31 and 32. Respondent was informed partway through 2012 that about the Exeter report, and that happened in April 2012, paragraph 30. In May 2012, paragraph 31, came the 2012 Habitat regulations assessment, thank you, and in June 2012, on the 1st of June to be precise, came the notice imposing conditions, and that is to be found. I don't think we need to look.
yes, I mean, I understand that. I was just wondering whether in the time between April and June, he made any representations about the effect on him.
In the meantime, may I answer a question raised by my lady, Lady Black? The fish rent, the landlords have kindly waived that since 2013.
That's the 65 salmon. Yeah.
So we think the answer is that no representations were made, and that may partly be because although it was clear that conditions were going to be imposed, the fact that the notices on page 358 imposing a limit of 30, he certainly had no idea that his entitlement was going to be reduced by an order of magnitude and some.
So it's just when he gets the notice
Yeah.
of the permit limitations, the first he knows he's being
Yeah.
cut right down.
Yeah, exactly. unless I can be of further help.
No, thank you very much indeed, Mr. Hockman. Mr. Beard?
My lady, no.
Thank you. Mr. Marisi.
My lady, my lords, just a few brief points in the time I've got available. Mr. Hockman emphasised in his submissions the nature of the possession here as being a right of use, for fishing, which is not disputed at all by the agency. His submission was that it was entirely and in essence removed by the action that we took. Now, we say that's wrong for the reasons that I outlined, but really it turns on the Posty case, which I don't go back to. But the Posty case is important because the possession there was effectively identical for our purposes. It was a lease that conferred a right to fish. And nonetheless, the restrictions on that were held by the court to be a change of use, a control of use, rather than a deprivation. Why? Well, the central paragraph is paragraph 77, which I showed you, where the court said because it did not completely extinguish the applicant's right to fish. And that's the language that's used, did not completely extinguish the applicant's right to fish. And in that regard, I do rely on what the judge below said at paragraph 96, I don't go back to it, EB 173. The finding the judge made was that the right was not entirely extinguished here, because it can still be used to catch the 30 fish for personal use or consumption, or for leisure use for Mr. Mott himself. 30 fish has a value of £3,000 on Mr. Mott's evidence. That is obviously a significant reduction, no question, but it is not to render it entirely extinguished or entirely worthless. And that's why I rely on the Posty case in relation to that. Secondly, submissions were made about the individual and excessive burden test. And I think we were also taken to the Bank Mellat case. Can I just briefly ask you to turn up that authority? So it's in Authorities Bundle 1, tab 2. The passage that I want to go to in the electronic bundle is 672, so EB 672, 671 on the hard copy print. It's paragraph 70 and 71. Now this comes from the judgment of Lord Reid, who, as the court will know, was dissenting. But as Mr. Hockman rightly said, these comments are very much mirroring comments that were made in the majority view. But at paragraph 70, about 4 lines down, after mentioning Sperong, the court has described its approach to striking such a balance in different ways in different contexts, and in practice often approaches the matter in a relatively broad brush way. In cases concerned with A1P1, for example, the court has often asked whether the person concerned had to bear an individual and excessive burden, see James. The intensity of review varies considerably according to the right in issue and the context in which the question arises. Unsurprisingly, given its international court, its approach to proportionality does not correspond precisely to the various approaches in the contracting states. And then 71, an assessment of proportionality inevitably involves a value judgment at the stage at which a balance has to be struck between the importance of the objective pursued and the value of the right intruded upon. Clearly, in the end, my submission comes back to the context here, and the objective is really twofold. One is, as you know, the protection of environmental interests of the utmost importance, European sites, the highest level of nature conservation protection there is, and in addition, the protection of the fishing stock, which is not just about the environment, it's also about the protection of the rights of all fishermen in the estuary to the protection of the stock.
Well, Mr. Hockman says that the agency didn't turn its mind at all to the question of the impact this would have on Mr. Mott, nor did it ever consider whether he might be an appropriate candidate for compensation. Is that correct?
Well, the position is I can't point you to a document in the history of this which shows specific consideration being given to the impact on the livelihood of Mr. Mott, and that's recorded in a statement of facts and issues. The reality is that the decision-making process was focused on the habitats regulation assessment, to which that question was not relevant for the reasons that I explained.
I think we've got misbehaving in the...
Yes. I have that very much in mind.
I thought you might have, yes, yes. In other words, when we're thinking about the impact of an individual decision upon an individual's fundamental rights, evidence that the public authority has actually taken into account their fundamental rights can be influential in encouraging the court to think that what they've done may be proportionate.
My lady, accept that, and it can be relevant to the question, but of course the court is asking the question. The court is in a position. I'll come to the position as between the judge and this court in a moment, but the court is nonetheless reaching a view for itself on whether a fair balance is struck. And
oh yes, and misbehaving, we allowed Belfast to get away with not having thought about it at all.
yes, yes,
We did.
And so, my lady, this court has the relevant information that Mr. Mott wants to put forward about what the impact is on his livelihood. That information is before this court as it was before the High Court, and we say, with that evidence in place, the position remains that the environmental interests here are so significant and outweigh the impact on the individual to a degree where I say there's no requirement for compensation. And it feeds into my further point, which is...
I mean, it goes back to the point I was making at the beginning, that the High Court has decided that it was not proportionate,
Well,
and which was, as you
yes.
pointed out, is a value judgment they had to make. Should we be interfering with that?
Well, my Lord, I will address that. I will
Yes.
address that point, my Lord. I'll do it now. My Lord, in terms of deference to the judge, Mr. Hockman's position was that for the first time this afternoon, that there should be deference given to the judge's judgment. That wasn't a submission he made before today, but deference he thought should be given, save for where he didn't agree with certain findings of the judge, where he was inviting your lordship to take a different, lordship and ladyship to take a different view. But the important point is, can I just ask, the key thing here is that the case I think my Lord Carnwath referred to was Re B, where the majority view was that one would look at giving deference to the views of the judge. But can I just emphasise the difference in the context? This court will well know Re B was a care order case. We were talking about care proceedings, I think, lasted 20 days with oral evidence. This is not at all the same kind of context in terms of deference. This is a judicial review, no oral evidence at all, no hearing of witnesses. You have the same material that the High Court judge would have had, and are in my submission, equally good as position to look at this. Now, beyond that, there is a further point. This court has looked at the Article 1, Protocol 1 issue in far greater detail than any of the courts below, for a very simple reason, that the vast majority of the argument in the courts below was focused on the irrationality argument.
But the one thing we haven't done,
Yes.
and maybe it's completely inappropriate that we should, is actually ask ourselves, yes, these are environmental concerns. Environmental concerns are, of course, important and have become increasingly important in recent years. But they're not all equally important. Merely to say that something is environmental doesn't surely mean that it is more important than the interests of human beings. And there are difficulties in assessing. Clearly, those environmental concerns which go to the interests of the future of the human race and indeed everything on the planet, that is pretty important. But human beings could eat other fish than salmon. So, in the general scale of things, where do we put the preservation of salmon stocks as against other important interests?
Well,
I'm trying to accept that environmental concerns are, of course, of great importance for the reasons that you give.
My lady, I say, in this case, very, very high up the scale indeed, because the preservation of the salmon stock is one of the features of interest that led to the designation of this European site, i.e. the highest level of protection was given, based on what feature? Well, one of the features was the preservation of the salmon stock. And the view's been reached by the agency, in addition, that absent these restrictions that have been imposed on fishing across the estuary, there would be an adverse effect on the integrity of the European site. So it's not just about we lose the salmon, it's also about what the effect would be on the adverse integrity of the site if there are no salmon in the river. So because the salmon are a key feature, because they are protected under the highest possible designation of a European SAC, in my submission, this is a case where the environmental interest is at the highest point of the scale. Because of those interests are protected by European law, because there is a risk of an adverse effect on the integrity of the site.
And what does adverse impact on integrity mean?
Well,
This is, the Wye is a salmon fishing river, so
Yes.
this has
Yes.
got a certain
Well-
kind of cultural importance. We're back to cultural heritage and so on. And people like to eat salmon, and particularly like to eat wild salmon.
I think it's more than that, possibly. Certainly, I think,
Well, I'm not trying to downplay it at all. I'm just
I think
interested.
David Attenborough might think it was slightly more significant than that.
I think there are some others.
Some others might think it's more to do with catching them than eating them, because the Y fishery is currently preserved for people who just catch them and put them straight back again, as I understand it.
Well, that's what I meant about the cultural interest.
Yeah, that's what I mean.
Well, my lady, in terms of the question you asked me about integrity, what does that mean? That question is answered by the Sweetman case, which is in the bundle, because the question that was referred there was, what does it mean to say adverse effect on integrity of a site? And the question is, you have to judge the harm against the impact of the conservation objectives of that particular
And we preserve bats and natterjack toads, even if we don't eat them. We think that.
Yes, it's not all about eating, obviously, but
Well, yes, but I was thinking about nuts,
Yes.
bats and natterjack toads, particularly bats, when I asked the question.
yes. And this clearly comes back to what I say is a fundamental part of our case, that a fundamental objection remains that we say it's not appropriate under Article 1, Protocol 1, to require there to be compensation for stopping people damaging our most important nature conservation and sites with the highest level of environmental protection. It's not appropriate in my submission. That's Trailer and Marina, which I rely on in particular, paragraph 61. And of course, what's said there is if you spend the money paying people to stop damaging these protected sites, then the money can't be used for positive steps that further the conservation objectives of the site. And that, of course, fits with the polluter pays principle, which I do very much continue to rely on because of the passages which Lord Carnwath identified in the exchange he had with my learned friend. It does include environmental disruption and degradation. And in my submission, if you are doing something which risks the integrity of an SAC being damaged, that is clearly environmental disruption or degradation. And secondly, in the further passage that's set out in paragraph 3 of the judgment of the Privy Council, it's not just about the polluter principle applying to remedying damage that's already occurred. It also extends to the implementation of a policy of prevention of environmental disruption. So if we're trying to stop somebody fishing because it will damage the integrity of an SAC, we are, in my submission, taking action to implement a policy of prevention of environmental disruption. And that does fall, in my submission, within the polluter pays principle.
Can I just ask you something? I know you're running out of time, but on the question of deference, as I understood your original case, it was that the deference should be given to the agency because they know best about the balance.
Yes.
But they didn't balance against the individual interests of Mr. Mott in this case.
Well, my
so
submission would-
you maintain that?
No, what my submission would be they know that the agency should be given deference because they are in the best position to judge what the level of environmental harm is that needs to be stopped. I can't push my submission further than that.
And I'm sure you'd accept that even if the agency had considered, it would still be for the Judicial Review Court to do its own exercise.
Still for this court to strike the fair
Well,
balance.
the Judicial Review Court, whether it's for this
Well-
court, it's another matter.
Well,
A court.
A court.
well, a court. And then my learned friend made some submissions about how the fair balance worked in terms of the overall limit that we set and how that was allocated within the limit. And can I just make some brief submissions on that? The overall limit that we set, the 221, is not under challenge here for being irrational or whatever else. That limit has a rational basis and is lawful. Beyond that, the dividing up, you've seen how it was done on a basis of equal division between the different types of use. This is an exchange I think I had with Lady Hale this morning. Even if we'd given all 90 to Mr. Mott, or indeed all 221, to the exclusion of anybody else fishing in the whole of the estuary, it would still, in my submission, lead Mr. Mott to be making pretty much the same arguments he's making now. He would still be saying that well over 50% of his interest had been removed. And then can I just add one thing? I won't go to it now, but in paragraph 50 of the judgment below, so it's core bundle 1, electronic bundle, page 161, in May, Mr. Mott was invited to meet the agency and the authors of the Exeter report to discuss its contents.
Sorry, what paragraph is that again, please?
Paragraph 50 of the judgment, CB1, EB161. So there was a meeting he was invited to where he was able to meet with and give his views on the Exeter report and also agency officers. And it said he failed to persuade either the authors or the agency to change their view.
So there was that degree of consultation.
There was a chance for him to express his views on what should happen here based on, he's talking there, I mean the focus there is on the Exeter report, because he was saying that it was not a correct basis to limit fishery. So that's paragraph 50 in the findings of the judge below.
May I just interrupt for one moment? Firstly, to say that I don't think my learned friend is saying, and we would certainly disagree if he were, that he was told at that stage what the catch limit was going to be. And secondly, I hope it's clear from what I've been saying that irrespective of rationality, the total catch limit in the context of an A1P1 assessment is certainly being called into question. My learned friend can't simply say, oh, well, that's immune from challenge. Everything is under challenge in the context of our A1P1 argument.
Can I just deal with one other point? I know I began this morning by offering you additional documents, which is a terrible start, so can I complete it with a terrible finish? But these, at least, you've requested. Can I just hand in three things which you asked for this morning? One is just the cover sheet for the Emerson and Seymour, but you asked for the earlier versions of the legislation that we were discussing this morning. Can I just make, to finish, one or two observations on that? That we were discussing, if you recall... Oh, yes. You've got any spare? There's spares coming right here.
We have not been supplied with this material and didn't know it was coming, I'm afraid.
It only arrived while you were on your feet, I'm afraid, from Chambers.
Doesn't look very contentious.
Well, I hope not, because the court asked for the older provisions, and so we thought that they should be provided. Section 26, which was the one we were discussing, if you recall, the provision that we looked at was sub 4 in the new one, which introduced, which had a provision on the right to compensation. Not the right to compensation, but there was a power given to the agency to compensate in the new provision of Section 26 where it affected somebody's livelihood. And if you look at the old sub 4, so this was all changed in the 2009 Act, the old sub 4 was actually more restrictive in the sense that what it said was the Minister shall not confirm an order under this section unless he's satisfied that the terms of the order relating to the selection of applicants for licences are such as to secure that any person who during the year preceding that year held a fishing licence to use as an instrument of any description and who's dependent on fishing for his livelihood will be able to obtain a fishing licence to use an instrument of that description. So you couldn't actually use a limitation order if you were going to sort of stop somebody pursuing their livelihood. And that was replaced by the 2009 Act by a may.
Yes.
So it's actually a reduction in the...
But that's where the compensation...
That's where the compensation
comes
in 26, yes.
Yep.
And then 212 is another provision that my own friend, I think, put in the bundles, which is one of the ones on compensation for fishery bylaws. And this was amended at the same time in the 2009 Act. And you'll see section 212, previously in subsection 1, gave an entitlement to compensation if a bylaw, fisheries bylaw, injuriously affected you. And what that's been replaced by is a discretion to pay compensation.
Which section is that replaced by?
It's now it's in the SB2, so it's in the Authorities Bundle 2, page EB 2195. 2195 is the current version of that provision. So the only submission I make is that clearly across the board there was a reduction in terms of those provisions in the protection given to those affected by these provisions, albeit as we discussed earlier, these are actually not the provisions that we're directly concerned with in this case. I think that the only thing I was going to finally, I'm going over time. There was one other point, which was when my learned friend took you to the learned judge's judgment below, he began his judgment by distinguishing Trailer and Marina, the judge, in first instance, on the basis that nobody had argued in that case that the controls amounted to a de facto deprivation. And that is just completely the wrong starting point. Trailer and Marina, paragraph 67, that was exactly what was being argued in Trailer and Marina. Unless I can assist you further, those are my submissions. Thank you.
Thank you very much indeed, Mr. Morrissey. We're very grateful to everybody for all their submissions, both oral and in writing, and I assure you that we will take as much account of the written submissions as we have of what we have heard today. We know that for very different reasons this case is extremely important to Mr. Mott and to the agency, and we will now go away and try and work out where a fair balance lies.